Foreclosure Protection. My name is Rick Baker, and I'm a consumer bankruptcy attorney in Orlando, Florida. And I want to talk to you about protecting yourself from foreclosure and foreclosure lawsuits. And one of the first things that happens is you've been served the lawsuits. A process server or deputies knocked on your door and served your papers. And you look at those papers and you see you've been sued by your mortgage company. Now, the first instinct is to file an answer, and ask yourself, well, should I defend this lawsuit and respond to it? The bigger question really is, should you keep the property? And it's not an easy decision to make, but you have to ask yourself, is the house really worth keeping? Forget the legalities, look at the numbers. Now, equity. First of all, ask yourself, is there any equity in the property? In this real estate market, values have dropped considerably, and if you owe more than the property is worth, you're underwater. The question is, how underwater are you? We all know the real estate market is going to come back. We just don't know when. Is it going to be a year, 2 years, 5 years, or longer? So look at your equity, pull comps, take a look at it, look at what you owe on the property, and see where you stand. The other main issue to focus on is affordability of the payment. Is the payment affordable to you? And the question you want to ask yourself is, has your income changed? Or has the loan changed? And there are different ways to deal with each of those issues, but is it a reasonable interest rate? Is it an adjustable rate mortgage? It's going to continually change. Has your income dropped temporarily or permanently? So equity and affordability of the payment are really the main factors to look at. So what are your options? What should you do with that piece of real estate, and how do you make that decision? Well, option number one is to litigate. This is where you file an answer and defend the lawsuit in state court and fight the mortgage company. Common defenses and affirmative defenses and counterclaims include, challenges to standing. You may have heard about, people challenging based on, well, the lender doesn't own the note or they don't have the note. Well, this all relates to whether they are a real party in interest with legal standing to actually bring the foreclosure lawsuit. So this may be an option, but, there are many law firms out there that are defending people in these cases, some successfully and some not so successfully. Many times I call these law firms pay-to-stay law firms, and they basically just drag out the litigation, and it may result in you losing the home anyway. So think carefully before you decide to litigate in state court. Now, option two is a loan modification. Many people are seeking loan modification to change the terms of their loan, and seeking a modification to lower the payment or reduce principal. The problem with loan modifications, it's a very frustrating process. If any of you have tried or attempted loan modification, you know that you frequently have to send the same documents 10 times. You talk to a different person every time you call your mortgage company. So you really have to think about that and watch out for these scam companies that are out there that just really take your money and promise a loan modification and then really don't do anything. And there are many of them, and then they're gone in the middle of the night, and people pay a lot of money and get no results whatsoever. Now, option number three is to cure the problem and cure the arrearages in a Chapter 13 bankruptcy case. You always have the right to cure in a Chapter 13 case, and that means simply entering into a court-supervised repayment plan under Chapter 13 of the Bankruptcy Code. One of the advantages of this approach is that if your payment is affordable and your interest rate is reasonable, and you were out of work for a period of time, but now you're back to work and you want to just cure or catch up the payments, this is an excellent way to do this and isn't dependent on a loan modification. Now, another huge advantage is you may also be able to strip off a second mortgage or a third mortgage or a home equity line of credit. And this occurs and is allowed in Chapter 13 cases where the value of your home is actually less than you owe on your first mortgage. And if that's the situation, at least here in Orlando Division in the 11th Circuit in Florida, we can strip off junior liens. So when you strip off that junior lien, you're bringing the value of the property a little closer to what you owe on the property, perhaps. And it may be an excellent way to, solve the equity problem. Now, option number 4 is seeking a loan modification in a Chapter 13 bankruptcy. Kind of the best of both worlds. Dealing with other debts, but also trying to modify your mortgage and possibly strip off a second mortgage in the process. Here in Orlando, Florida, in our bankruptcy court, the U.S. Bankruptcy Court has launched a mediation program supervised by the Chapter 13 trustee. And the idea behind the program is to streamline what is an otherwise very frustrating process by requiring the lender to designate a decision maker. So, in other words, you're sitting down at mediation with the lender, their attorney, and have exchanged documents prior to the mediation. And these are starting to get some traction here in Orlando. It seems like you're taken more seriously when you're in a bankruptcy case, and the lender understands that there's a judge and a trustee who kind of have their eyes on things. So it seems to be working very well, and many of my clients are seeking this option. And the final option, number 5, is to walk away from the property. And sometimes this is the best option. Look, if you're $100,000 upside down negative equity and your payment is twice what you can afford, and you've tried modification, or the numbers simply don't work, you may want to surrender the property. Now, the best way to surrender a property, in my opinion, is in a bankruptcy case. And why is that? Well, because you get a discharge of the debt, and there's no liability later. But if you just walk away or think that you can just send the keys back to the mortgage company, it won't work. My opinion is that in the next year, 2 years, we're going to see a wave of foreclosure litigation that relates to deficiency judgments. In other words, when they're done foreclosing on everyone, they're going to come back and pick up the pieces and go after people for the difference on what they got at the foreclosure sale. So it's not an easy decision, especially if it's your home. But whether it's your home or whether it's a piece of rental property, you really need to think in the long term. Seek professional counsel, consider your overall financial situation, and think, where do I want to be 5, 10, 15 years from now, and where do I think I'll be given the value of the property and what I owe on the property. If it's not a good investment and you don't think it will be down the road, then your decision gets a lot easier. For more information on bankruptcy and other issues, please visit my website, legalquestion.com. If you have questions, we have answers, and I'd be happy to also talk to you via email, and you can email me at info@legalquestion.com. I'm consumer bankruptcy attorney Rick Baker. Thanks for watching.